Hello, everyone. This is Tom Fox back again with Matt Kelly for another episode of the award-winning Compliance Into the Weeds. Today, we're going to take a look at the Department of Justice and a broader look at anti-corruption enforcement. Matt, you wrote a blog post about this topic last week. Has the situation changed since then?
What I wrote about, Tom, was the coming into view of the new Trump administration and its Justice Department nominees to lead that department. The president made several different nominations toward the end of last week, several of them actually being rather reasonable, and one being off the wall bonkers. So we could talk about what Trump's leadership team for the Justice Department, if they are confirmed, what would that mean for the department? What would it mean for America at large? And also, what would it mean for compliance officers? Because, at least in theory, it could mean a whole lot of not much change. Maybe I'm wrong. We don't know. But it was an interesting twist in developments as things started coming into view.
So, what's coming into view from your perspective regarding FCPA enforcement, Matt?
Here's the thing. So Trump nominated Matt Gaetz as his attorney general. In fact, to be technical about it, all that Trump did last week was he said he will nominate Matt Gaetz. He has not actually formally done so yet, but Matt Gaetz would be his attorney general. He is a now resigned Florida congressman who resigned just last week ahead of a House Ethics Committee report that may or may not come out in public. But the investigation was that Matt Gaetz has been accused of sexual misconduct with minors, human trafficking, drug use, probably other offenses we do not yet know. But that person would be in charge of the Justice Department, according to Donald Trump. Now, that's the one that's off the wall bonkers. But what Trump also did was he nominated, or again, just announced he will nominate two of his personal attorneys, Todd Blanche and Emil Bove, to be, respectively, the Deputy Attorney General, so that's number two, and the Associate Attorney General, who is number three at the department. Blanche and Bove both represented Trump while he successfully fended off the federal cases against him for the taking of classified documents and keeping them in the bathroom in the garage at Mar-a-Lago, and also his January 6th insurrection activities, and he beat that rap. On the other hand, Blanche and Bove also represented Trump with his document case in New York, where he was accused of fabricating and falsifying business records, where he was convicted earlier this year. So they didn't beat that rap. But anyways, Gaetz, Bove, Blanche, those are the three who would be running the Justice Department. And then also, and frankly, I think somewhat unusually, because you don't see this appointment or this nomination come out this early in a presidential incoming administration, Trump announced who he wants to run the Southern District of New York, which is the U.S. Attorney for Manhattan and Wall Street. And that is none other than Jay Clayton, the former chairman of the Securities and Exchange Commission in the first Trump term. And Tom, you and I talked about Jay Clayton and his activities at the SEC many times during those previous 4 years. And now Clayton is back, and he's going to be the U.S. Attorney for New York, and he would be Wall Street's top cop. So, Tom, I will say my belief is that he's a terrible choice to be Attorney General, and we can talk about that. But Blanche as Deputy AG, Bove as number three AG, and even Clayton as U.S. Attorney for Manhattan, these are not far-fetched ideas as Republican administrations go. And we can talk a bit more about their experience, but actually, absent Gaetz and his off-the-wall whatever he's going to do to ruin the Justice Department, these other three, you could look at and be like, yeah, that kind of sort of makes sense as Republican administrations go. And they might not portend all that much change specifically for corporate compliance concerns. There's a lot of concerns about other things, and we can get to those too, but that's what's going on so far.
And I guess I would go even a little bit further to say that, once again, absent top position, the other three are really firmly within the mainstream of
Yes.
what we've seen as law enforcement officials, prosecutors, or regulators within the U.S. government. They have significant U.S. prosecutorial, Department of Justice, and government experience. You mentioned Jay Clayton specifically, and He has a large body of work that we can draw upon to see what some of his priorities might be. I think it fits directly within what typically would see from a conservative administration. It does give me some comfort that the inanity of the AG pick will not be as bad, but nevertheless, I think there will be a refocus on certain priorities, and maybe we could explore some of those, at least start with the ones you talked about in your blog post.
I think that you should let's start with who these people are, because there is a lot of concern that Trump has nominated his two personal attorneys to be number 2 and 3 at the Justice Department. Think of it this way, everybody who's concerned about that. If Blanche and Bove had not represented Trump personally, I don't think anybody would be blinking an eye that these two are going to have senior level positions in the Justice Department. They did work in the Southern District of New York. They have brought corporate corruption cases, national security cases, corporate fraud cases. They know what they're doing, and they would be reasonable picks in any Republican administration. This one, because Trump is basically nuts, so you have an asterisk next to it, and you can see the nuttiness in nominating Gates to be the boss. But if any other Republican were president-elect, even if they had been Trump's personal attorneys in some parallel universe where a president-elect Nikki Haley or Marco Rubio is making appointments, again, nobody would blink an eye at Blanche and Beau. Blanche, by the way, was a Democrat for a long time until he did leave his posts to open a private practice representing the president. And I'll give him credit where it's due. Even though he had a Supreme Court that was always stacked in his favor, he won his pretty good cases on the federal charges. Them and Jay Clayton, I don't think you'd see any change. FCPA enforced FCPA enforcement did not go away in the first Trump administration. I don't think it's going to go away now. You could look at it through a certain Craven lens that I think Trump would see the utility of bringing certain cases for political ends against people he wants to antagonize in Cuba or Iran or Venezuela, countries like that. So maybe more prosecution of foreign companies, certainly more prosecution of sanctions, because sanctions are going to be his go-to move to deal with Iran, presumably North Korea. In theory, Russia, I don't know what Trump's going to do with Russia. That's above our pay grade here. But like sanctions enforcement, again, not going to go away if you're in financial services and you're working on Wall Street. Clayton knows how Wall Street works. For the last 4 years, he has been running Apollo Global Management. That is one of the largest private equity firms in the world. He was a senior partner at Sullivan Cromwell, which is one of the most esteemed law firms in the country. I think he still might have some sort of affiliation with Sullivan and Cromwell as well. He did run the SEC. Clayton is going to know how financial crime happens. He's going to have his views on what a reasonable corporate defense might look like. But I don't think Clayton is going to drop corporate prosecution or prosecution of corporate misconduct. I don't think Blanche and Bove would do so either. They might have different priorities. They might have different expectations on what an effective compliance program is. And we can talk about that too. But all of these folks, they wouldn't be afraid to bring corporate prosecutions. So I think compliance officers, I don't want to say should take comfort in it, because you're still going to go through stuff if you have misconduct. But anybody who's thinking, oh my Lord, we're never going to see corporate enforcement again until Trump goes, I don't think that's true. And I'll stop there for a moment.
I don't think it's true either, but I have to take it several steps past that. And I'm going to start with an interview that from NBC News entitled, "How Will the Trump Administration Prosecute Corruption?" And Fry Wernick was quoted in this article, and he had a very interesting idea, which was that there is an axis of adversarial nations, or adversarial to the United States right now, obviously China, at least at this point, Russia, and certainly and Iran. And he sees that FCPA could be, quote, thoughtfully enforced in a manner that could be useful to complement foreign policy efforts, a kind of America First approach that I think the Trump administration could be quite receptive to, end quote. Now, that seems a lot to me, potentially retribution. And I would take it several steps further, because I think we're going to see three categories of FCPA prosecution. Number one, against adversarial nations. And that, at least right now, that's China. You're absolutely right to neither one of us know where Russia might be, but China, hopefully no one in this listening to this podcast is doing business with Russia or Iran right now. But I think any U.S. company doing business in China or any Chinese, a U.S. subsidiary of a Chinese company is directly in the crosshairs. Matt Ellis was the first to sound the clarion call of other countries who may have a political system antithetical to what Trump wants, i.e., socialism. Brazil, United Kingdom. I think those countries could be next in line for aggressive FCPA prosecution for retribution against companies from those countries. And now I think there's going to be a third group, which may be a tentative U.S. ally, but may get crosswise on trade sanctions. And if our listeners will remember the potential champagne and wine sanctions or tariffs that Trump threatened to put on France, clearly, and I think we could see significant prosecutions against countries that individually piss him off and he wants retribution. If we have Matt Gaetz as Attorney General, I think the word will go down that they will go after companies from those countries. So I think we could see an increase in targeted enforcement as a part of a U.S., if not foreign policy, certainly of a, tried to figure this word out, whatever retribution is a verb or adjective or adverb. But let me flip it to you because I think there's actually a positive thing for compliance professionals that I think self-disclosure will become even more significant. And the reason I think that is it will give the Department of Justice a way to make it appear that it's being fair and even-handed. And if you self-disclose under the current policy, remember, the default position is a declination. And if you can meet those standards, I think we'll see more declinations without any penalties other than a disgorgement of profits. So I think we could see more declinations if the Department of Justice wants to show that it is thoroughly prosecuting FCPA cases.
So I think that's right, that fundamentally the dynamic that the corporate enforcement program has set up, which again, that traces all the way back to 2017 and even a little bit before. But during the first Trump administration, the then deputy AG, Rod Rosenstein, framed this up that basically the more you make it easy for the Justice Department to prosecute you, the easier they will make that resolution. And that principle has held through all of the Trump administration, all of the Biden administration. And so why would that not hold true in the second Trump administration? Why would they try to make it harder? I do have some questions about, say, how they might revise the evaluation guidelines for an effective corporate compliance program, but I don't think it would be anything that corporate defense lawyers or compliance officers would really find dismaying at all. They would relax their expectations for the documentation you provide. Maybe they would relax their expectations for if you're going to claw back executive pay that was handed out under false pretenses. Maybe there are some other things that they might do to make it even easier for you to say that you've cooperated. But the voluntary self-disclosure leading to no criminal penalties, that is the part where I'll die of shock if we see a criminal penalty against the U.S. company in the second Trump administration. Crazier things have happened. I might be wrong. But I think that they will go to great lengths to make it easy for you just to show up and say, I did this bad thing. Now I'm going to fix it. And they'll say, great, fine. How would that change the calculus for some corporate lawyer out there who would say, let's just not disclose at all and let's clean it up and hope nobody notices? That is another thing that I think we need to think about. I wouldn't be surprised if you do hear more cynical types on the corporate defense bar saying you don't really even need to disclose it at all. Let's not forget Matt Gaetz is still going to be a terrible attorney general. He's still going to have most people probably ready to quit and go somewhere else immediately. I do question who's actually going to do this enforcement because a whole bunch of very good lawyers at the Justice Department aren't going to put up with a nitwit like Gaetz, who should be nowhere near the Justice Department. So I do wonder about that. Tom, I do have some other issues that I think compliance officers might want to contemplate here. For example, requiring CCOs and CEOs to certify the effectiveness of their compliance program at the end of a term. Will that go away? Will it remain? I don't know. We should remember that, to the best of my knowledge, nobody's actually signed one of these yet because they are at the end of a 3-year term, and this whole idea is not yet 3 years old. So I don't think anybody has signed anything yet. And I do wonder if this goes away in the Trump administration, maybe nobody will ever sign one. I'm not sure. I am curious how the Justice Department will handle whistleblowers filing key tam lawsuits under the False Claims Act, which normally whistleblowers in the False Claims Act, that's a big moneymaker for the federal government. They get billions every year. There are federal judges now running around thinking that whistleblowers under False Claims Act actually are illegal and unconstitutional. There's at least one judge who has made that ruling. Of course, he was in Florida. I'm not sure where the Justice Department would fall on that, but that's another concern I do have. I wonder, Tom, will we see more prosecution or interest in the Foreign Extortion Prevention Act, which they just passed last year to hold corrupt officials accountable? And I think Trump would probably say that's a wonderful way to screw over people I don't like in Iran or Cuba or North Korea or Brazil or Venezuela or any other number of foreign nations. So maybe we'll see more corrupt FIPA prosecutions there. However, we should not discount the fact that Matt Gaetz, if he is confirmed, and I fear that he will be, he is still going to make the Justice Department an unbearably dysfunctional agency. So even if Blanche and Bove have good ideas, and even if they and Clayton do have sincere intentions about making corporate enforcement stick, but in a more reasonable manner, if the whole building is on fire and the org chart is in tatters thanks to Matt Gaetz, I don't really know what that will mean as a practical basis for a lot of compliance programs and companies trying to get a resolution with the department. If it's a total mess under Matt Gaetz, who knows what might happen?
So let me go back to the False Claims Act or the key tam actions because that intrigues me as well. That law has been around since the Civil War. That's the United States Civil War, not the English Civil War. And it has been a key part of the U.S. government's attempt to fight fraud, waste, and abuse in government contracting now for nearly 170 years. If courts are going to hold that private prosecutions are illegal under the Constitution, they're going to have to take that same logic as they did with the inside or the courts of the Securities and Exchange Commission with their ALJ process. And then if they do the same with the National Labor Relations Board, they're basically going to eviscerate the ability of the federal government to use those venues, and it will stampede everything to a federal court, which would completely clog up the federal courts. And then we haven't heard Chuck Grassley weigh in. And as everyone knows, he's the godfather of at least the modern FCA. I don't think that will hold up in the U.S. Supreme Court, but I think we have both been wrong about this Supreme Court before.
Yeah.
The second thing is I'd like to pick up on your last point. In addition to a potential fire at the Department of Justice, what happens if every prosecutor is assigned to prosecuting immigration cases because there are not enough prosecutors in the INS or any other service to prosecute the millions of immigration deportations that Trump wants to do? And DOJ has to turn its resources to that priority. Will other types of cases kind of go by the wayside and we won't have anything? Just open questions in my mind.
Tom, actually, I worry about that a lot. Look, I am for a secure border as much as anybody else, and the nation has made it clear that they would like to reduce the number of illegal immigrants living in the United States and remove them by force. Okay, that's what we're going to do. But imagine, like Matt Gaetz has already said he wants to take a wrecking ball to the FBI, for example. So if you have a cybersecurity matter where normally you're under attack by a ransomware person and you would call the FBI, except there's nobody there to take the call, either because a whole bunch of good people have quit to get more money working in the private sector at a consulting gig, or because they're all busy chasing around every illegal immigrant they can find. What are you, the company facing a ransomware attack, supposed to do? For the last, I don't know, at least 10 years, every FBI symposium I have gone to on cybersecurity, they've always been saying, when you're under attack, you should call us. And I do think a lot of companies are now open to that idea. For a long time, they weren't. For a long time, if you were under a cybersecurity attack, first thing you did is shut up about it because you didn't want people to know. But now companies understand that ransomware attacks are going to disable your ability to operate. They're going to cost you a fortune. We're going to need help. And they go to the government for help. But Matt Gaetz has made this organization so dysfunctional. There's nobody at the FBI to help you. There are no prosecutors who are willing to issue subpoenas and trying to figure out what's going on with an attack. I do think that is a real concern, that there's going to be a huge brain drain and manpower shortage from these agencies, which are still vitally important to help companies with legal trouble get that resolved. Now, back to your point about the administrative law judges and whether they might be unable to adjudicate cases at the National Labor Relations Board or at the SEC or in a False Claims Act case or anything else, we might say that seems like a problem. Says that's the goal. I mean, when we talk about could the NLRB and various other agencies totally see their enforcement abilities eviscerated, everybody in Trump land, including Matt Gaetz, would be like, yeah, that's it, man. What did you think we were going to do? So I do think that would then lead to clogging things up in the federal courts, which is not going to help any company because your law firm is just going to keep on billing you at 800 an hour at least. And where does that get you? So I don't know. I still wonder if Trump is really serious about Matt Gaetz. I do wonder if Republicans in Congress might actually have a spine. I don't see why they would be because they haven't stood up to Trump really so far. But if they vote Gaetz down, then we'll see some other person come in as AG. Tom, it does strike me that Jay Clayton, as the U.S. Attorney for New York, could he do the job? Absolutely. It seems like an odd thing because frankly, it is beneath his station, in my humble opinion. I think that Clayton would be perfectly fine as a deputy attorney general, as an attorney general. I wonder if they are parking him there at the Southern District of New York so that when Gaetz finally does implode in a maelstrom of incompetence and dislike, maybe they move Jay Clayton in. Like that works if that's the theory. I'm not sure it is because it implies a level of strategy that Trump and his team seem not to exercise all that often. But there are people he is nominating to run justice, which in certain circumstances, they wouldn't be bad. And they would work with compliance officers. And I think compliance officers in the compliance community would like to work with them. Matt Gaetz is not one of those people. He's going to be a wrecking ball. How does this work if you've got reasonable people at the mid levels, but there's a wrecking ball swooping back and forth above your head? I don't know. So we've got a lot more to see with the Justice Department. But like I said, if you look at it in a certain light, at a certain angle, some of the things that Trump is doing, they're not terrible for compliance officers, although they could be terrible for others.
Let me maybe end by circling back to something you talked about or touched on, I should say, a little bit earlier, and that was a defense counsel or even an in house compliance professional suggesting let's remediate this and not self disclose. Number one, there's no legal obligation to self disclose,
No.
meaning number two, it's not illegal to remediate a situation. And that's a valid decision for a corporation to make within a range of decisions you could make. Perhaps a self disclosure might be deemed the most conservative, but it's still a valid decision. And if it's reasoned, perhaps more companies might move to that. And that's something that, once again, may seem counterintuitive, but would be positive coming out of this administration's Department of Justice.
I would just say, I think the variables that go into that calculation are going to change. It would be reasonable not to self disclose if it really does seem like a trivial matter. You have had no issues before. You have fully remediated and you've documented all of that so that if anybody ever does ask, you can prove that you reached a good conclusion that this wasn't necessary to do. But the new variable here is that maybe no one's ever going to find out because it's not like prosecutors of justice have any time to do anything except prosecute immigration cases anymore. And half of them have already quit because they can't stand the attorney general. It's not like anybody's ever going to find out. That is a very cynical reason or variable to include in your calculations. I can't really say I like it. I can't say it jibes with my sense of what an ethical culture should do. If you can have an ethical culture that reasonably concludes this is a minor offense that doesn't need to be self-disclosed, that's one thing. But if you're just saying nobody's ever going to find out, so let's just not tell anyone, that's not motivated by a spirit of ethics. That's motivated by a spirit of covering your rear end and just calling it a day. And that doesn't sit well with me. And I fear that we might see more of those calculations come up, though.
I think what you just described was a legal analysis.
Well,
On that note, Matt, get what our listeners, we will be off the week of Thanksgiving. So we'll be back with you the first week of December. Matt, happy Thanksgiving.
you too. Bye.